This video is about what a jury will have to decide in the case of Ted Wafer. I personally do not know what they will decide. I made a previous video and I indicated that I slightly believe that he would be found guilty. My own personal view is he does not deserve to be found guilty. It will be a very close case. Now, if you take the George Zimmerman case, I believe that was a very easy case for the defense to win. If you take the Michael Dunn case, I believe he will be found guilty. There's very little question in my mind that he will be found guilty. Then you can look at two other situations. Bo Morrison, he was a young man in the state of Wisconsin. He was at an underage drinking party. The police were coming. He ran and hit on somebody's porch. The homeowner shot him with one bullet. He died. The homeowner was not charged. Then there's Sarah McKinley. She was a young woman down in Oklahoma. Her husband had recently died. Two people were trying to break into her house, most likely to get pain medications, and she shot one of them dead, and she was not charged. Then, in sorting out the news, I think both sides have put a little bit of spin on it. I think the McBride side has put the most spin on it. One, their first pronouncement was that Renisha McBride was shot in the back of the head. Well, the coroner's, or the autopsy indicates she was shot in the front of the head. Then they're claiming that she was just looking for help. Well, how do they know that? Then her parents' attorney said she had car trouble. Well, I guess you could characterize it as car trouble. The car trouble became because she smashed her car up. Then they try and characterize her as a small woman. I read the autopsy report, and she weighed 184 pounds. Then there's a little bit of spin from the Wafer side, too. One, apparently when he talked to the police, I have not seen the police report or the tape of it, he said the shooting was a mistake. Now his attorney is saying it was self-defense. These two are not necessarily 100% irreconcilable, but it's pretty close to being irreconcilable. Then we have to look at the facts of what the case are about. One, or A, is Renisha McBride crashed her car a little before 1 a.m. She not only crashed her car, some people saw her. She attempted on multiple times to get her car going. These people offered her help. If she was interested in getting help, there they were at 1 a.m. in the morning. It was a little before it when she crashed. I saw pictures of her car. It probably wasn't the worst crash in the world. The people saw her leaving. They indicated she was disoriented. They did not know whether it was due to the crash or she had been drinking. Then one of the things that we have yet to find out is where was she for 3.5 hours? It's hard to tell where she was. She did the car crash a little before 1 a.m. She appears at Mr. Wafer's porch at about 4:30 in the morning, so she was gone for 3.5 hours. if I had to make my own guess, I would guess she left the scene of the crash, she went walking, she passed out, and then she came to and she went rapping on people's doors. It's my understanding that the distance from the crash site to Mr. Wafer's house was approximately 1 mile. Then there was her blood alcohol content. At the time of her death, it was 0.218. There are alcohol charts around, and assuming from the time of the crash she consumed no more alcohol, which, since we don't know where she was, we don't know that was true, that would mean her blood alcohol at the time of the crash was about 0.28. If you look at various charts that are around on the internet, at 0.218, your ability to act rationally is gone, and if you go to 0.28, you're at about the level where your ability to have your motor functions work is nearly gone also. That would be essentially falling down drunk. Other facts that I consider relevant, although some of them are semi-trivial, there was no doorbell. That, in fact, could be why she was pounding on the door. I looked at the various photographs and I expanded them as well as I could on my computer, and there did not appear to be a doorbell. Then there's the question of the porch. Many people call many different things porches. This porch seems to be a slab of concrete that is smaller than 6 by 6 feet, and there's 2 or 3 steps up to that, what is called a porch. Then you have to look at the shotgun he used. It was a pistol grip shotgun, and I would think about the only function for a shotgun like that is to shoot another human being. Then there's reference to being not at close range. That was on the autopsy report. What not at close range means is more than 30 inches away. Then there are some things that tend to mitigate what Mr. Wafer did. There's what's called the sleep inertia effect. What that is when people are awakened from sleep, as Mr. Wafer was, they're noticeably unable to think as well as if they were fully awake. Of course, as stated, and then also there's people get scared. The reason the military went to assault rifles was that in World War II, many soldiers would freeze up when people were shooting at them. If you combine these two things, that seems to go in with Mr. Wafer's claim that the shot was fired by mistake. If he had taken the safety off the shotgun and he got nervous, there could have been a time when he pulled the trigger because he was just nervous and jumpy about what was going on. There's also reference to a paintball incident in the police report. Apparently, according to the news, he was asked if anyone was out to get him, and he reported an incident where someone had shot his car with a paintball gun, and he had just wiped off the paint. Then you get into the law. I did not go through the elements of the offenses, but in the event that Mr. Wafer cannot produce a defense such as mistake and or self-defense, the state would easily be able to prove second-degree murder. They would be able to prove manslaughter, and they would also be able to prove possession of a firearm while committing a felony if they can prove either of these two. It should be noted that second-degree murder in Michigan is different from second-degree murder in Florida, where George Zimmerman was tried. In Florida, you have to prove that the person evinced a depraved mind. All you have to do is show that you did the shooting and it was not premeditated. Then, with regards to the state of Michigan, they do not have a defense of diminished capacity. That would somewhat get into the issue of sleep inertia effect. So if you said that, no, I wasn't mentally ill, but due to not being able to think well, it would lessen the ability to make reasonable decisions, that diminished capacity is no longer allowed in the state of Michigan. In Michigan, before you can use deadly force, you have to, one, have an honest belief that you're going to suffer great bodily harm or death, and two, it has to be a reasonable belief that you will suffer great harm or death. Michigan also has the Castle Doctrine. The Castle Doctrine states that the individual against whom the deadly force is used is in the process of breaking and entering a dwelling. In this particular case, I think it would be reasonable for Mr. Wafer to conclude that Renisha McBride was breaking into his home. It is a fact that there was a screen door on the door she was pounding on that was locked, and she had not broken through that door. There was another door that he opened and apparently shot her through it. So it would likely be reasonable to expect her to be someone who is breaking in, given that it's 4:30 in the morning. And the individual using deadly force must honestly and reasonably believe that the individual is engaging in the conduct described in A. There is good reason for someone to suspect that. However, this is essentially where the jury is going to have to make their decision, and they could make the opposite decision. So I think the case is going to be an extremely difficult case for both sides, and I do not know how it is going to come out. It is very sad that there appear to be two, generally speaking, good human beings, and a very strange set of circumstances brought them together. One person lost their life, and the other may wind up spending a significant amount of time in jail or prison and have to go through the expense and other problems associated with a expensive trial. So essentially, two lives were ruined.